Hi, I'm Anna Denton-Jones of Refreshing Law, and this is our first week of Knowledge November 2024. Today we are focusing on the duty to make reasonable adjustments that an employer has under the Equality Act, and specifically who does it cover. It's quite a wide coverage. So the first category of people that are going to be covered are job applicants. The definition that's used in the legislation is interested disabled persons. So that will be both people who have applied for a job, but also extend to people who are saying they might apply for a job, who are expressing an interest in doing so. So the employer is going to be expected to make reasonable adjustments for them. So some example cases would be a case against the Government Legal Service a couple of years ago where somebody had Asperger's syndrome and was going to struggle to answer a multiple choice format for a test that had been set, and requested to instead provide short written answers, and the employer refused and failed to make a reasonable adjustment in that case. A more recent case is the case of Mr. Mallon, who had dyspraxia, and the employer's process, and this is very important in these days where people are thinking about artificial intelligence and pieces of software that can support them in the recruitment process. They had an online system where he would have had to register, create an online profile and complete an online application form, and he was sent a number of emails from the employer essentially challenging him to explain what his issues were with the system. The employer there was criticised that somebody should have just picked up the phone to the individual and said, how can we help you? And they failed to do that. So that's the first group, our job applicants. Second group of people are going to be covered by the definition of employment. It's worth understanding that the definition of who an employee is, for the purposes of this legislation, is broader than perhaps the category of people that we ordinarily think of as our employees. So casual workers are going to be covered. Those individuals who are on a contract of apprenticeship will be covered. Those people who contract personally with us to deliver a service, so a freelancer, is going to be covered. So it's worth bearing that in mind when you are looking at the duty to make reasonable adjustments. The duty can even extend to ex-employees. So there have been cases where somebody has resigned as a result of their disability and then brought a claim against the organisation that they previously worked for. I'm thinking of a case involving the police here, where the employer still has an obligation to make reasonable adjustments. For example, if you were running an appeal process. Sometimes even I've had cases where somebody clearly with mental health issues has tendered their resignation, where you've actually said to them, is this what you really want? Shall we just pause? We won't take this resignation as active, if you like, and let's manage your health situation. If you still want to resign in a few weeks' time, then we can talk about it again, because there is such a risk around the person's activities otherwise. So that's a quick gallop through who's going to be covered by the equality legislation, and look forward to seeing you in week 2 of Knowledge November.